Ms. Hussy, good morning. Ms. Hussy, you're here because you've been accused of one count of methamphetamine, possession of methamphetamine, one count of possession of cocaine, one count of possession of drug paraphernalia, 3 charges in total. Ms. Hussy, I've read the complaint in your case, and Mr. McDaniel provided Mr. Mitchell and myself a case from 2 days ago, dated October 1st.
It's Williams v. State,
which would have been 2 days before the arrest, that may be relevant in your case. So I'm going to ask that you listen to Mr. McDaniel and Mr. Mitchell, and then we'll see where we go from here. Mr. McDaniel.
Got her, going back to the presumption, there's a presumption of unconstitutionality when you search someone without a warrant. And, and in this case, it's on the officer to provide enough information that would create a probable cause. And essentially, it appears the probable cause is based solely on the smell of marijuana, or if not solely, it's nothing else in there really brings anything to a probable cause that the items that they was in there searching for were there. Nothing to bring to that level.
Thank you, Mr. Mitchell.
Just a moment, Your Honor. Nothing from the state at this time, Your Honor.
So I'm not real clear. I called our law clerk this morning for some guidance on when in the October 1st, 2nd District Court of Appeal becomes final. And it really, in the bottom of the opinion, it says there's some language in there about finality at the very end of the opinion you sent, Mr. McDaniel, and that just confused me even more. So what's clear is the way that I've been reading this, because there was a split at least before October 1st between the District Courts of Appeal in Florida. What's clear is that you even by the most law enforcement friendly opinion, you had to have something. Well, no, that's not necessarily true. The way I've been reading those cases is you needed something besides smell. So my question is, what did he have other than smell, he being the officer? And what the complaint says is this. He had odor marijuana, allegedly, what he thought was marijuana. I asked her if there was CBD, hemp, or marijuana inside the vehicle. She admitted her friend sometimes left such items in the car and pointed to a package of zigzag cone wraps. The problem is, in his question, some of the items in his question are legal, that being hemp. So basically he asked her, are there any legal or illegal items in your car? And she doesn't answer it specifically, at least not in what he put in his complaint. Instead, she said, sometimes my friend leaves some of those things in my car. So does that, coupled with an odor that is either marijuana or hemp, based upon the law I'm reading, give him probable cause to search? And I don't know about that. Mr. Mitchell, what's your thoughts?
I'm of the same mind. I'm not entirely sure about it either.
Mr. McDaniel?
I think there needs to be more in it. I mean, obviously, I guess, and if you're, so if you take out the smell of the marijuana, and that's an action that can be used on something else, would just that other issue that he brought up be anywhere close to probable cause? And if it's nowhere close to it, with just the smell of it, raise it above probable cause? I think the answer to that would probably be no, based on those answers and the questions he asked.
I just find it hard to believe that was his exact question and that was her exact answer, because if it was, there would have to be a follow-up question. He would have to clarify. It doesn't make sense if she says there's some things in here that are legal. Essentially, that's what she'd been admitting to without some follow-up questions. I don't think that's it's not very well articulated at all. And I think in that kind of situation, I agree with Mr. McDaniel. Without the smell of marijuana, the rest of it's not even close. Now, the smell of marijuana can get you there, but it's got to have something to go with it. And I just don't think that's not enough, because he didn't ask the right questions or put the right answers down. Or if she gave them, he didn't articulate them in the complaint. So I'm going to find no probable cause on these charges. Now, that doesn't mean the case is dismissed. What it means, Ms. Hussey, is that if the state attorney's office and law enforcement can correct this, ma'am, by filing an amended complaint, they very well may. And that'll be up to them to try to do that. Hopefully there was a camera on. Hopefully the officer had a camera on, and the state attorney's office can see exactly what question or questions you were asked and exactly what your answers were. And if there's additional evidence, or if the state feels like they want to, if it's exactly what the officer put in the complaint and the state wants to have that heard before Judge Garcia, they certainly can do that by filing information against you. But for right now, I think this officer missed the training that we did back in March or April. We covered this specifically in a training then, and that officer wasn't at that training, so I don't think he has been brought up to date with this changes in marijuana law that's happened in the last year and a half. So there's no probable cause today. You're going to be released from custody. I need to make sure that we've got an address for you, because if the state does charge you with an information, I want to make sure you get your court date. Is it the Dean Road address? Is that still accurate, Ms. Hussy?
Yes, sir.
Make sure you check your mail so that you don't miss your court date, ma'am, if the state does charge you. Ms. Hussy, do you have any questions?
No, sir.
Wish you the best, ma'am. Ms. Simco, good morning. Ms. Simco, you're here for first appearance accused of one count of trafficking in methamphetamine, one count of possession of methamphetamine with intent to distribute, and one count of possession of drug paraphernalia. Ms. Simco, there is probable cause in the complaint for these charges, which I know allegedly occurred about a month ago. Ms. Simco, a little less than a month. Ms. Simco, as far as I can tell, you're entitled to a bond. But I want to listen to the attorneys before I address that bond. Mr. McDaniel, anything?
Your Honor, I would just, ask for a couple issues, I guess. Issue number one, it appears like this is based primarily, if not exclusively, on the smell of marijuana. And I know there's new case law on that, but there's also older case law, that has to be pieced together about it. Also happened in September, and I'm not sure why the deputy who wrote this complaint then went out there and arrested her at her house, and it's been a month and has never asked for a warrant on the case. So there is a presumption that anytime that you take items from someone or arrest them, or essentially you take someone, there's a presumption that it's unconstitutional unless the complaint has enough information into it as to why the taking was constitutional. And I'm not sure if the complaint even just basically based on the smell is enough. But then to go out there and arrest her a month later at her house without getting an arrest warrant creates some issues, I guess, Your Honor.
Mr. Mitchell.
Nothing at this time for first appearance purposes. I'll keep it like that.
So, Ms. Simco, I'm not aware of any law. There isn't a law that requires a warrant if the officer has probable cause that the felony's been committed. Under the old system, the state attorney's office like to review warrants, review cases, and they would ask for a warrant. This kind of case, anything more than a day old, that changed probably a month ago. The state attorney's office no longer requests to be involved in the warrant review process. So sometimes officers don't get warrants if they don't have to. I disagree with Mr. McDaniel. Mr. McDaniel, if there's some case law, I'd love to see it, but I don't think an officer has to get a warrant if there's probable cause for a felony. Secondly, at the time this stop was made, the law is different than it appears to be today, because Mr. McDaniel provided us a case that was issued 2 days ago from the Second District Court of Appeal that reverses their opinion from the Owens case, which was the end of last year. So before 2 days ago, there was a split among the district courts of appeal on smell of marijuana being the basis for a search. That appears to be no longer the case after 2 days ago. However, even now, even after 2 days ago, smell of marijuana cannot be the sole basis for the search. And there are other bases for this search that the officer alleges. Specifically, the officer alleges that you admitted someone had been using marijuana in your vehicle. That's what the complaint alleges, ma'am. And that is a separate additional basis in addition to a smell. So I think there's clearly probable cause. I'm going to set you a bond of trafficking that normally would set for the amount of $50,000. Possession with intent to distribute will be $15,000. Possession of drug paraphernalia will be $2,500. Your total bond, Ms. Simco, is $67,500 cash or surety. You have a condition of random urinalysis. Ms. Simco, if you do post the bond, ma'am, you have a condition of random urinalysis. That, ma'am, you can be aware that you're probably going to be drug tested at some point. So that's going to happen very likely. You're also going to get a notice for your court date, which will be November 4th at 8:30. And you're going to get a chance to use the phone in just a few minutes, ma'am, to try to post the bond. Lastly, I am taking into account your criminal history, which is very lengthy. Ms. Simco, do you have any questions?
Yes, sir.
All right, ma'am. Wish you the best. Taran Hussy. Mr. Lee, good morning. Mr. Lee, Your wife is in the courtroom, sir. You're here because you've been accused of 1 count of armed burglary, 1 count of felon in possession of firearm, and 1 count of grand theft of a firearm. Mr. Lee, there is probable cause for the charges. I will say that when I read the complaint, it was kind of a close call on probable cause. I think there's enough there for probable cause, but there's not an overwhelming amount of guilt or evidence of guilt in the complaint. So obviously that's a factor for me to consider for bond purposes. What hurts you is your criminal history is terrible. I think you've been to prison 4 times. Is that right, Mr. Lee?
Yes, I did my time for that.
All right, so I'm going to set your bond, but let me listen to the attorneys before I set that bond. Mr. McDaniel, anything on behalf of Mr. Lee?
We just asked for a reasonable bond.
Mr. Mitchell?
Nothing at this time, Your Honor.
All right, Mr. Lee, you've got that armed burglaries. I think that's a first-degree felony. I'm going to, for bond purposes, I'm going to treat these as third-degree felonies, even though they're higher degree. But the reason I'm doing that is, as I mentioned, there's some evidence, there's probable cause, but it's not a overwhelming amount of evidence. Your bond's going to be $5,000 on each count. Your total bond is $15,000 cash or surety. Cash or surety means you can go through a bondsman. Whatever you negotiate with a bondsman is between you and them. You don't have to come up with all that money. You do have a condition of no contact with that location that this charge allegedly occurred. It was one of the hotels here in Mariana. So, Mr. Lee, what's going to happen, sir, is you're going to get to use the phone. I'll answer that question for you. You'll get to use the phone in just a second or just a few minutes, and you can try to post that bond, 2548. And I'm going to tell you the hotel this allegedly happened at so that you can know that you can't go back to that property while this case is pending. Let me ask your wife if she has any questions while I'm pulling that up. Ma'am, you have any questions, ma'am? No, Mr. Mitchell.
It's the Super 8 motel located at 2226 Highway 71.
Thank you. So no contact with that Super 8 motel. Mr. Lee, the other thing I'm going to do is ask the jail to give you a notice for your court date. That would be November 4th at 8:30. They're going to give you that notice, and you'll get to use the phone in just a few minutes, sir. Do you have any questions?
Yes, I have 0 phone numbers. I can't even contact my wife. I have 0
Okay.
phone numbers.
All right. Is that, you have a question? You won't,
Yeah,
you won't
I
mind.
need my wife's phone number.
Here, if we want to do it where we don't get it on the record, I could text Mr. McDaniel his wife's phone number.
Mr. Mitchell says he'll text Mr. McDaniel your wife's phone number if that's okay with you and her.
Yes,
Is that
sir.
okay with you, ma'am? So your wife's going to give the phone number to the prosecutor. The prosecutor's going to text it to your attorney right now, okay?
Okay.
All right, wish you the best, Mr. Lee.
Yes, sir.
You'll get that phone number in just a minute or two.
See them and go
You can go ahead. No, I was just telling him it'd be a minute or two. No, go ahead, please, Mr. Mitchell. Thank you for doing that. Corporal, I think a camera may have got knocked off a little bit. We can barely see Mr. McDaniel. If it needs to be shifted to your left when you're facing the camera. Not zoomed in, but yeah, that's better. Thank you. I can see it. Whoa.
Right about there?
Yeah, that'll work. That'll work. Thank you. Richard Smith is next. Actually, I think Mr. Smith, I got a text, Mr. McDaniel, from you saying that he was not going to be participating in the first appearance.
Yeah, it is not, he's just going through some issues. I let him know there's gonna be a hold up on, and I'm gonna let this Elizabeth Simpson know where he's at, and we'll just have to go ahead and first appearing.
Perfect. Mr. Mitchell, anything?
I think all we need to do is just give him his pretrial date.
All right, thanks. Sounds good. So it is no bond on that warrant, and his pretrial looks like it's going to be October 21st. And thank you, Mr. McDaniel, for notifying his attorney. The next case we have is William Bauer. Bauer, good morning, Mr. Bauer. You're here because you've been accused of 1 count of aggravated assault on a law enforcement officer, 1 count of resisting an officer without violence, and 1 count of approaching a first responder with a specified intent after warning. Those second 2 charges are misdemeanors. The first one's a felony charge. And Mr. Bauer, as far as I can tell, you're entitled to a bond. There is probable cause in the complaint. I'm going to listen to the attorneys before I set your bond, sir. Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Mitchell?
Nothing at this time, Your Honor.
Mr. Bauer, that I'm going to set you the normal bond I would set for these charges. That third-degree felony bond's $5,000. The other 2 are misdemeanors. Their bond will be $2,500 each. You have a total bond of $10,000, but it's cash or surety. Cash or surety, Mr. Bauer, means you do not have to come up with all that money. You can go through a bondsman. That's what a surety bond is. And you'll get a chance in just a few minutes, sir, to post that bond by using the telephone, call whoever you wish. Mr. Bauer, you do have a court date of November 4th at 8:30. The jail will give you a written notice. If you post bond, they'll give you that notice before you leave the jail. Mr. Bauer, you will not get a notice in the mail. That notice they put in your hand will be the only copy you get. So make sure you show up for that court date. Mr. Bauer, do you have any questions?
No, sir.
All right, sir. Wish you the best.
Thank you.
Stara, Simco.